Are we recording right now?
Yep.
Yeah, okay, we're going to cut this out.
Yeah, it's all right. Now we're going to do a straight to camera with this, but later. Welcome to Divorce Cafe, the podcast where we demystify, detangle, and hopefully detox the legal processes that follow a separation with the experts in the relationship property world. Today, we're talking about prenups, or contracting out agreements, those least romantic of proposals. On the home team,
I'm Shelley Fennell.
and I'm Tina Henderson.
We are partners in law and friends in life. We work with people going through a separation to navigate what is usually a very complex and bewildering process.
So Shelley is a numbers whiz who worked in relationship property law until she went through her own separation and experienced it all from the other side of the desk. I love working in this area of law because it feels like important work and because I want to be involved in making it better. And this podcast and the conversations we're going to be having are part of that. Today's episode is all about prenups, or as we call them in New Zealand, contracting out agreements or Section 21 agreements. The agreements fit into Divorce Cafe, I think, because although they're generally put in place before or during a relationship to avoid disputes after a separation, the reality is that they can be the cause of huge conflict and cost after the end of the relationship. Today's guest
is a specialist in relationship property with a particular focus on trust and the Property Relationships Act. She has a master's degree in the subject. She has made a speciality of complex contracting out agreements, and in particular agreements between couples entering into second or subsequent relationships with sometimes significant assets and adult children of their own. Amanda Morgan is a fellow director at Henderson Reeves. She started out at Henderson Reeves in litigation in 2009, and she now focuses on non-contentious relationship property matters and trust and commercial work.
She's here to discuss what it takes to make an agreement that will do what you need when you need it to, and importantly, how to ask for a prenup without losing the nup. Amanda Morgan, welcome to Divorce Cafe.
Thanks for having me.
Before we get into the juicy bits, in our first segment, we like to ask our distinguished guests to pull a random question from the distinguished bucket. Amanda, I apologise in advance, but half of these questions are insightful interrogations of life in the law, and the other half were made up by Shelley.
Okay.
So, you...
Good luck.
Who wants to do it?
You read it.
Oh, I read it.
Yeah.
If you were having a dinner party and could invite 3 guests from the living or the dead, who would you invite?
That's quite a safe one. There are
That's
some quite
very
juicy
safe.
ones in there.
Hard, but safe. I would probably invite Nelson Mandela.
Mm.
I would invite Helen Clark. And I would invite probably Richie McCaw.
Richie McCaw, that would be a really interesting. Could possibly stand a chance of getting Helen Clark, but I don't know about Richie McCaw. His wife might get in the way. Yeah, okay, nice one. Shelley.
Okay, this next section is called the basics. So we're going to jump in and put you right on the spot, Amanda, by asking you, can you summarise what is a contracting out agreement and why do we have them?
Certainly. So essentially contracting out is in the name. So what you're wanting to do is basically reach your own rules or contract out of the default rules about how your assets and liabilities get classified and divided in the event that your relationship ends. So that's either because you separate or one of you dies during the relationship. So that's sort of it in a nutshell. Basically, you're wanting to reach your own rules of engagement into this marriage or relationship.
Yeah. And it's how does it differ from like a contract like a lease?
So the contract itself is governed by the Property Relationships Act 1976. So it's quite an old piece of law, but it had some reforms in 2002 to include de facto relationships as well. And with that specific legislation comes specific rules around each party having to get independent legal advice, the fact that it has to be in writing and signed by both parties, and that the lawyer that has given you the advice has to witness it. So there's some more, or I guess more stringent formalities around the actual nuts and bolts of how the agreement's done.
Hence why when you do a contracting out agreement, each party takes the agreement to a different lawyer.
Correct.
For independent advice.
And it's a bit more than just witnessing it, right? So
absolutely. Yeah. So I think there's a huge misconception. Well, I know in my practice anyway, I've had agreements arrive on my desk and people ring and say, hey, I just need like a really half-hour appointment, if that, you just need to witness my signature. And then you sort of say, what sort of agreement is it? Well, it's a prenup or a contracting out. And it's not a quick and easy witness. So as a lawyer, when I'm signing off on an agreement, I'm actually signing a certificate saying that I have explained the effects and implications of the agreement to the client. And when I'm explaining it, what I'm comparing it to is, what would you get if you separated or died under the law compared to what you're going to get under this agreement. So that then entails another investigation as to what assets and liabilities you have currently, where they've come from, the source of those, how long your relationship has been. Is it a first relationship, neither of you have kids? Is it a second relationship, you've both got kids from previous, you might be having kids together? Or are you later in life and you've got adult children and there's no prospect of you having kids together? So it's actually more than a one appointment process. And I think that's where people feel, clients anyway, feel a little bit frustrated with the process at times, because I don't think that's explained to them. Like the education's lacking to say, this is not a $500 job.
Well, in the movies, they sign it just before they go to the aisle, don't they? And I've heard you saying it's a forever document.
Yeah, which is not entirely correct, because these agreements can be overturned, but the reason they get overturned is because generally they're really unfair, or the advice actually hasn't been sufficient, or the process hasn't been followed adequately. So yes, the reason I say they're forever is I say you need to channel time and energy and thought into it at the outset, so that you're happy with the arrangements now whilst you're signing, but also in 10 years when your circumstances have changed, also in 30 years, because potentially, unless you both agree to get rid of it, which hardly ever happens, you're going to be stuck with this.
So the next section that kind of segues nicely is stuff we find interesting. And the reason we wanted to do this episode on contracting out agreements is because of precisely that, because knocking down contracting out agreements has become such a big area and a big issue. And when you look at the variation of agreements and the variations in the advice, the time and care that's been taken to take advice, it feels like overturning agreements is going to become an even bigger industry. And, God forbid, lawyers are going to be up on the stand.
Absolutely,
So, and it's also an area that can be pretty morally fraught.
Absolutely, yeah. I think what I find in my practice is, when relationship property specialists are dealing with these types of agreements, which really it should be a specialist in this area of the law because it is complex, they generally are schooling their clients up as to what they can expect. I find when lawyers who don't regularly practice in this area prepare seemingly simple agreements and then refer the other side onto a lawyer and say it should be done in about half an hour, there's just a sort of lack of understanding, I think, in education about, well, actually, no, the lawyer you see is going to have to ask questions. It won't be done in one appointment. You can expect at least several appointments.
And we're going to talk a bit later about a big case from Australia, which must have cost the parties hundreds of thousands of dollars between the three different levels of court case, because it wasn't done thoughtfully, because it wasn't, it was rushed through. So
and there was pressure in that case as well, like a time pressure.
So who typically comes to you for a contracting out agreement?
Generally, I find it's either young couples starting out, and one of them is coming into the relationship with a significant deposit for a house, for example, or they've received a significant financial injection from family, whether that be an inheritance or a gift from mum and dad or a mum and dad's trust, and they are wanting to ring fence a certain aspect of it as they're buying their first home. So that's sort of one area, and then most commonly is second relationships. And as we all know, blended families are completely sort of the norm now, and are only going to be more normal as time, well, not normal, but just more common as time goes on. So yeah, second relationships where people have got kids from their earlier marriages or relationships, and also a lot of older people coming together later in life, and where one person has built up a substantial or just more wealth than the other party, which they want to protect for their own bloodline.
Or not, they just have they each have different assets that they really want to specifically
leave.
Which would otherwise become relationship property under the law once their relationships or marriages 3 years or more.
And the increasing value of property in New Zealand and Auckland and everywhere just means that people are coming to relationships with really significant amounts of assets that they want to protect. And so when you're talking about millions of dollars of assets, to spend a couple of grand on that contracting out agreement is
as a percentage of your asset base, it's so small. The other point with the older like later in life couples, I'll call them, is that if they were to lose, or not lose, but have to part with half of their assets on a separation or death, they don't actually have, they may have been retired, so they don't actually have the time or the working life to recoup what they've, had to divide. So it is quite appropriate in those, and again, it's all been built up pre-relationship. So through no joint efforts of the parties themselves, it's all pre-relationship.
That's a really important distinction, isn't it?
Yes,
in terms of agreements.
And I think you can compare that to the younger, like starting out couples. Where actually the likelihood is, apart from maybe a big gift or an inheritance, they're both coming in with relatively nothing or a student loan often. They haven't had kids, they're likely to have kids together and get married.
They're starting out in their careers.
Yeah, so it's quite a different proposition to be dealing with as a legal advisor.
Yeah, because that core principle from the Act is the one about equity of contribution. So everybody's contribution to the relationship is equal, and they should be sharing equally the fruits of their labours.
So you're obviously talking about the different scenarios. So do you think in terms of contracting out agreements, is there a spectrum from sort of easy entry level up into, you get what you eat, what you kill, so you just get to keep whatever is yours?
Yeah, absolutely. And I always say to clients, look, there's no rights and wrongs with how you arrange these things.
Yeah.
It's what's actually specific and relevant for you in particular. So it's not a cookie cutter, get a precedent kind of approach, but they do vary. So as I say, generally with younger people starting out, it's generally quite simple. There's not generally companies or trusts involved at that point in time. We're simply ring fencing a capital contribution to the relationship as one person's separate property. And actually when you talk it through with them, the balance of things, they're happy just for the law to dictate what happens, because that's really what's fair. The law is relatively fair. And then you contrast that to later in life where there might be two family trusts involved on each side, there might be businesses involved, so company structures, and they are wanting to, they financially are separate from one another, they want to remain that way, and they keep everything separate.
And often they've been burned.
Quite often. Or they've been widowed, so I guess there's an emotional attachment to what the deceased and one partner has built up together and protecting for their own kids.
And it's such it is a really specialist area, because although with those sorts of couples you can say to them, yep, your agreement's going to be more easily enforceable, because those moral reasons to not depart from equal sharing are kind of gone when you've built up the asset. But then you start verging into the Family Protection Act type thing. So Family Protection Act obviously is where you have a moral obligation to adequately provide for someone who you had a close relationship with in your life, and mainly your partner and kids who are dependent on you. Now you can't contract out of that, from what I understand.
You can't. And so there's sort of several pieces of law all operating in tandem, which you have to have in mind. So you're absolutely right. The contracting out agreement is done under the Property Relationships Act and just deals with assets that would be, apply to those. Then you've got the Family Protection Act, 1955, so old piece of law, which again is there for good reason, to protect people who are left essentially destitute on death. You can't contract out of that, so then you've got to think about legal structures. We've got the contracting out agreement. Does the client then need to think about a trust to transfer safely once they've done the contracting out agreement?
Make adequate provision.
Or make adequate provision. But
work out what adequate means for the two of them.
For the two of them. And that's a really good point you kind of make, because what people often come to you and say, well, if I separate, I want X, Y, and Z. And then you pose a question, well, what would you want if you died during the relationship? So you're trucking along happily and you get hit by a bus, and it's often quite a different scenario.
But I do think people need to be educated on that, because I think there is an aspect of every person wants to look out for their children, because you're obviously responsible for them as a parent, and you're so focused on that, looking after your kids, that you've got a contracting out agreement that you're not sharing anything, and then you're not making provision in the will, and you're thinking, well, you actually had a relationship with this person, like a primary relationship, and while you do want to protect your kids, you actually want to look after that person.
And those are legal obligations.
And the law says you have to.
Nobody wants their will overturned except lawyers, right?
I mean, people generally do want to look after their spouse or partner on death, at least to have them in the same level of living standard as they have enjoyed during the relationship. And so there's lots of ways you can achieve that. For example, if the home is owned by, I'll just say husband dies, and it's owned by his trust or him, it might be that husband wants to leave the wife the right to occupy it for either for her life or a certain period of time, or upon a certain event happening, like a repartnering, for example.
We'll have to do a whole nother one on, in fact, we're going to do on relationships and death.
Do you think it's fair to say that contracting, we sort of covered this a little bit anyway, but is it fair to say they can get quite expensive? Why can't you just take their instructions, put it in an agreement and let them sign it? Why do you think you do need to be involved?
Well, legally you do, but also I think it's risky if you're not actively involved in providing advice, and robust advice a lot of the time, because it means that you're really leaving the agreement open up to be challenged down the track. So these agreements are done because one party does want to protect assets. So there is a disparity, and the person who is disadvantaged by the agreement, if there hasn't been adequate advice, investigation about what there is, there's been pressure or time pressure, or pressure to sign because I'm not going to marry you if you don't sign it, then I kind of think there's no point in doing it, because actually 10 years down the track that person will say, well, I felt pressured, I was pressured, I didn't get adequate advice, I had no idea what I'd be entitled to under the law, I'm going to seek to overturn it. Now, it is a pretty high threshold to overturn it, but they do get overturned. And so the whole point of doing it in the first place is just undermined, which is for certainty about what happens on separation or death.
Like having an insurance policy that you're not paying the
premiums on. Exactly.
And this is another reason, the reason that lawyers have to be involved is because this is social legislation. It's put in place to protect usually the person who has less asset, and for the benefit of the children of the relationship. And so what a contracting out agreement is it's somebody who wants to protect themselves or their own assets against some of those safeguards. So you have a lawyer involved, and they can kind of counsel you through the ways that can be done that are going to be supported at the end of the day by the law.
And I often find when people came, they don't want to disclose all their assets. So especially if you're 2 years into a relationship and you've got a complex kind of property structure, so you've got companies and trusts, and they don't want to disclose the values of the property, they don't want to disclose the values of the company, because that's quite a big thing for them to do, but they do have to do that, don't they?
Yes.
And anyone can look on homes.co.nz anyway.
Well, it's even about knowing what's even in existence. So if I sit down with a client and I say, okay,
well, that feeds into the next question. Sorry to interrupt. What's your process when someone comes to you wanting to? to do a contracting out
So
agreement?
if I'm getting instructed to draft an agreement or advise on it, basically I set up a first initial meeting and I explain to the client either via email or on the phone that this is the first meeting, we won't be signing the agreement at this meeting. So just to give you the heads up, you know, I want to be in line with your expectations that it's not going to be signed and sealed today. Which sometimes they're surprised about because they think, oh, well, I thought it was just a simple contract. Then I meet with them, and it's generally, depending on the complexity, but you know, an hour's appointment. And I'm getting I start generally with the details of the relationship. So when it started, their ages, their relative, like what they do for their jobs, relative income earning capacity for each currently, whether they have children together or from previous relationships, whether they intend to have children together, like whether it's possible they might have children together. And then I get into detail about the assets and liabilities that each have. So I'm asking, what do you have currently? Where did it come from? As in, did you acquire it pre the relationship starting or during? How was it funded? Like, did you get an inheritance to buy the house or you know, acquire a company or build up a company? And then I ask about their partners or spouses' assets and liabilities, so same detail. And then
values.
Yeah, and rough values, yeah. I will have done a title and company search pre the meeting, so I'll have done under both names, and a conflict checked as well to check we haven't acted for the other side. And then I discuss how the law is structured, and then I go through their assets and liabilities and give them advice generally about, if you don't do an agreement, this is essentially how your assets will be divvied up.
Because for some people, they might be like, oh, so my inheritance is going to stay separate. Yeah. Maybe we don't need to this.
Exactly. Or I didn't know my income from my job, but it gets paid into my separate account. It's my separate property. Well, no, it's not. KiwiSaver, whatever you're contributing during the relationship. So there are often people are surprised about, you know, how things will be classified. And then I ask them, so what do you want to do? Like, how do you intend this to pan out if you separate or you die? And as I say, those answers can be different for each, generally are different and should be different for each scenario. And then I go away and I either draft the agreement if I'm instructed to, or I will, if I've got an agreement that I've had a look at, there's generally some tweaks to it, from minor to major, depending on how it's structured and what my instructions are. Then there can sometimes be toing and froing with the other lawyer, and then we can get another meeting lined up, and then sometimes you'll sign at that. But if it's complex, you actually can have several meetings, or if they're not actually agreed as to, after having the advice from you, how they want to structure things.
Or if there are things that they can go away and talk about.
Yeah, exactly. And then if there are other, like if there's a trust involved, and trustees technically can't be a party to a relationship property agreement. Some practitioners do include them, but technically it's not possible.
How do you bring them in?
Yeah, so I bring them in, I refer to the trust. I'll also refer to, like, when the trust was set up, who the trustees are, who the beneficiaries are, who holds the powers of appointment and things like that in the agreement. And then I will say that the parties agree that this agreement is conditional on the trustees consenting to the terms of this agreement as they relate to them. And then it's a matter of doing the trust documentation depending on what they're agreeing to. But it could be agreeing to a right of occupation in the trust home for survivor, etc.
And making it conditional sometimes on that.
Yeah, because you want, like, for the disadvantaged party, you want to make sure that the trustees are not going to say, well, actually, no.
And for the advantaged party, because the agreement will become seriously unjust if the trustees don't perform. Yeah. So that's when they can get more complex, and therefore more cost is involved with those sorts of agreements. And obviously the trust will have its own costs, you know, as well for preparing documentation and ratifying what they've agreed to. Okay. Awesome.
So basically, the more trust, the more entities you have, the more complex it is,
Absolutely.
the more it's going to cost. I think that applies actually over
across the board.
Every area of law.
But then there's a good reason to have a trust. And if there's not a good reason, you shouldn't, you know, if you've got a trust in place, there generally will be at least one good purpose for it. So,
do you think that things, my initial question was going to be, are there any circumstances where you would say to someone, don't do a contracting out agreement, just rely on the law that's already in place?
Quite often. So there's a couple of scenarios. So particularly for younger couples who are starting out, and if they really don't have anything major, one of them doesn't have something major to protect, but they're just wanting to move forward and keep everything separate for eternity, I'll often say, like, the likelihood is you're going to maybe have kids, get married, one of you will take time off to look after and raise kids, maybe lose a bit of earning capacity. Like, this has the potential to become so unfair that it's likely to be overturned.
Yeah, in a few years you're going to end up throwing it out. Is there a point? Yeah.
And the other scenario is where the example of the capital contribution from a parent or a trust.
Yeah.
And actually you can structure that.
There are some alternatives.
Yeah, exactly.
Tell us
so
about
rather
that.
than distributing or gifting it to their child, they can structure it as a loan. And it can be a loan to one or both of them. If it's relationship debt, it doesn't matter whose name it's under, but ideally both of them.
So there's no misunderstanding.
So that actually if they separate, the trust or mum and dad can recall that loan back and say, well, I need it to be repaid.
Yeah, and that's a lot.
The caveat to that is you've always got to get that approved by the bank, but we're quite successful as long as you propose it in a way that ensures it's not going to be detrimental to the bank's interests and they're not going to compete.
Yes, so they rank second in priority after the bank, and you should record it. It should be in writing in a deed of acknowledgement.
And you make sure that it gets signed, and if it's not signed, you ask, why haven't you signed it? What needs to change? Because there's cases about that, aren't there?
Yeah, and we don't like to lose business because obviously that kind of thing is a lot cheaper, but it's,
we don't want to do
terms of the
unnecessary.
relationship, I think it's much easier to sign an acknowledgement of debt than it is to argue a contract.
Cheaper and easier. Yeah.
I think what you've got to keep in mind with prenups is the relationship's continuing, so you don't want to completely blow it out of the water with your legal advice, which they can become crunchy, and the issues are sometimes awkward to talk about.
They're really awkward.
And so I think that's always at back of mind is you want to be able to leave this meeting and go home and have dinner across the table from each other.
Question 8.
Well, do you
Sorry,
have any,
I'm jumping ahead.
No, this perfect, because we've got a question on that topic.
Which question is that, Tony?
Question 8.
Do you have any advice on how you can have that conversation in a constructive way that doesn't undermine this important relationship? I have some thoughts on it because obviously I've been through it from the client point of view as well as the lawyer point of view, because it is awkward conversations and one party is getting advised by one lawyer and one is getting advised by the other lawyer, and often they're both saying the other party is getting the best deal. Because it's kind of part of what you have to do as a lawyer to say, this is what this actually says, this is what it means, and then you're both coming home.
Well, and it also it starts reducing your contributions to your financial contributions, because that's what the lawyers are often,
that's your tangible thing you've got to think about and play with.
Why would you give away that? And then you're like,
and you get very defensive. I think you're entrenched in your position, and it's really, these are fundamental conversations.
I guess you feel cornered, like for the person who's generally one person is pushing it or raising it, and for the other person, it's like, well, what's the way through this? If our relationship's going to continue and I don't want to sign it in this form or that form, like how do we get through this?
Maybe that's a secret. It's just not in that form. If that's something that's
because it is, what am I worth to you? That is, I think that's.
Do you trust me? Do you not trust me that I'm not going to take you to the cleaners?
You're at the beginning of a relationship, it will be early days, and you're talking about what's going to happen when the relationship ends. It's really hard. You cannot do that in a way that it doesn't become personal. So
sometimes the way I tackle it is to say, you're paying me a hefty hourly rate. You need to blame me that this is but seriously, this is the advice I'm giving you. And I'm kind of forcing you to take it.
So you go home and say, my lawyer won't let me do this.
Well, and that
can sometimes be a really good way of actually deflecting off the person and as I say, sort of blaming your lawyer.
Giving you the confidence.
But I think you're right, because you're saying if you don't get some protection, this is really unfair, and the agreement can be overturned.
Absolutely. The other thing I say to people is like, try and talk about it. Don't make it the elephant in the room. Actually just tackle the issue in whatever way you guys do communicate best, and don't leave it kind of festering.
Sometimes laying it all out. I often ask, okay, well, just think about what would be fair if you separated in 3 years. What about in 5 years? What about in 10 years? And when you start to think like that, you know, people, it becomes a bit more real.
Yeah.
And they can see that maybe after 10 years, I shouldn't be keeping all of, you know, the house. I should be sharing some of those increases.
Yeah. And I think, like, the other point you made about the non-financial contributions, which I think do get overlooked, is to say, particularly for the party who might stay home and look after kids, well, that's just as valuable as the other party continuing to work and earn an income. And is it really fair that they get to essentially keep that as their separate property and give you an allowance whilst you're at home with the kids? You know, like, I mean, that's the extreme, but yeah, technically that's what could happen.
And there is some evidence to suggest, there is actual empirical evidence that when a working person has a husband or wife at home, they do better in their job. They make more
married
money.
men are supposed to live longer, right?
Are they?
Yeah, married women live less long.
Wow.
And single men don't live as long as married men. So, yeah. Do you think, I know Shelley, you made some submissions on this, but do you think it gets better under the Law Commission's recommendations?
Yeah, well, I definitely. So the Law Commission's recommendation, and
I think it was
2019. Unfortunately, it was a pretty comprehensive report. I can't remember; it was hundreds of pages. I remember reading. I haven't read all of it, but the government said we're just not looking into that at the moment because they wanted to do trust, and then I think they're doing estate planning, and then they might come back to this. But the one of the primary recommendations was that when people came to a relationship with a significant asset, the family home, they get to keep the value of it at the beginning of the relationship, and you're just sharing 50-50 in the increase while you're in a relationship. And I think that sounds really fair. I get a lot of people, we get a lot of people coming wanting that exact that exact scenario, because it is fair if you've come and you've built up assets, but then it doesn't seem that fair to say it's my house now and you know it'll be my house forever. I think it does feel fair to say we're going to share in the increase of value while we're in a relationship together.
Yeah, and the other part of that, those recommendations was the FISA, Family Income Sharing Arrangement, and so that was, we've had a podcast on spousal maintenance, but that's another way, it takes the conflict out. I think that's another area that it's got its problems, but
it's a way to provide maintenance or alimony or whatever you want to call it in a similar fashion to the child support arrangement, right, where you have a calculator and it's easy.
And it deals with that Section 15 argument, which is also a bit fraught about the person who stays home comes out not earning as much, so it equalises that.
And it provides an easy way for the spouse or the partner that doesn't have any income to get income without having to go to court. And I think just that simplicity, it might not be fair in every single case, but the simplicity and the ease of gaining access to immediate maintenance.
And if it's like the child support arrangement, IRD child support, you put it into the calculator, IRD collects it, there's a review provision, so that if you fall outside of the standard, that you can make use of that, or misuse that to beat your partner a little bit longer.
Okay, so when can things go wrong, do you think? When do these agreements fail?
I see them failing sort of before they get off the ground. When I've had a couple of experiences where there's been a really a complete imbalance of power. So one example was I acted for a person who had come from overseas and married a Kiwi person, and English was their second language, so they were not fluent at all. And it was a completely unfair agreement. So it just would never have stuck long term. And in that case, I did have to get an interpreter. I didn't feel comfortable that my advice was being understood, so I had to get an interpreter. And that goes the same for the young couples starting out and really keeping everything separate and not forward thinking to how fair or unfair this is going to be 5, 10 or 20 years down the track.
And what way it might detract from the relationship to not be building up something together.
Like, and I think the question is like, how do you intend to build any joint wealth? I hadn't really thought of that, I don't know. Obviously you've got the provisions of the Act where it can become unstuck as if, they haven't had independent legal advice, and that's independent firms, not within separate lawyers within a firm. If there's been inadequate advice, so really where you know that a person has just been to a lawyer who has spent half an hour and it's quite a significant agreement in terms of what it seeks to do, and it's just been signed off.
There was that case where they ended up looking at the lawyer's time records and saw that the lawyer had spent 2 units meeting with the client, and that...
which is 12 minutes, isn't it?
12 units in people speak.
12 minutes,
and that agreement got thrown out, and that there would have been some justifiable actions against the lawyer.
Yes.
Yeah, because the other parties can. So when there's a client on the other side, they can sue the other party's lawyer. So,
what's become quite more common since COVID too, and also with people cohabiting across the ditch and in other countries, is how you get these signed. So generally they are in person with a lawyer, and we haven't had any specific legislation to allow us to witness those remotely via Zoom or other video means. But during COVID, obviously things had to keep moving. And so I think it's really important to include provision in the agreement if you are going to sign remotely. And then also I generally do a fairly extensive file note about where the meeting for my client took place, in terms of were they at their home or their place of work, who else might have been present. Ideally you'd have a witness to confirm that at least the other side's not near or in the room, and that they have witnessed that person sign the agreement as you have via Zoom. So that's become much more common since COVID.
And your client's not going to be thanking you 15 years down the track if you're not able to give evidence that supports an agreement that they've been relying on. And if you haven't got all of those details.
But in terms of generally the times they come unstuck, in most cases, is the complete unfairness.
How about the overturning, so section 21? So 21F is void for failing to comply with the formalities. 21H, the court can give effect to an agreement that doesn't comply with the formalities if neither party's been materially prejudiced, and that's kind of comes in, I think, to those Zoom signing ones. And then 21J, the serious injustice exception.
Which is a fairly high threshold, but it does
until 2001.
It does happen.
It was just the agreement giving effect to the agreement would be unjust. Since 2001, all those reforms, seriously unjust. So I personally haven't, thankfully, had any cases where I've been directly at touch with involved, but the kind of quintessential ones are where there's a long relationship. So there's a very famous case which we're all familiar with, Clayton and Clayton, and essentially the contracting out was done at the very start of a marriage, and it was about a 30-year marriage off the top of my head, and kept everything separate. Fast forward 30 years and it's become completely unfair. So that is a clear-cut case of serious injustice. Yeah, so there's two ways, right? If the agreement was at the time of signing seriously unjust, so if it was just a shitty agreement or unfair, or if due to circumstances,
change in circumstances,
it becomes seriously unjust.
I know you've got a good case about this.
Tell
us about the case.
So
I like juicy.
We always like a good case. So I thought it'd be worth talking about that. There was an Australian fairly high-profile case a couple of years ago called Thorne and Kennedy. So this was an Australian property developer. He was 67. He had assets of between $18 and $24 million. He met an Eastern European wife on the internet. It wasn't quite as sordid as that because they both spoke Greek. They both shared the same religion. He met her family. It was. I hate to throw shade on some of these poor old characters in our cases, but so anyway, they met over the internet. And after a few holidays together, she moved to Australia. She was 36. She had no substantial assets of her own. She had no right to stay in Australia if the relationship ended. And that was fairly important to the outcome at the end. They became engaged. He was a bit of a big deal, so there was a media flurry, publicity around their wedding. Her family came over from Europe. Her dress was made. And then just over a week before the wedding, Mr. Kennedy says to her, jump in the car, we're going to see your lawyer and you're going to sign this agreement. And
True romantic.
I know, what a catch. It's a shame he
I hope it
died.
was a limo.
Yeah, he died partway through the litigation. But anyway, yeah, it's a shame. Anyway,
We don't take men, honestly.
so he drove her to her lawyer, who thankfully was a bit of a specialist and, well, not thankfully because it didn't make any difference in the end, but on the 20th of September, this was, he takes her to the lawyer's office. This was the first time that she'd been made aware of the contents of the agreement that he wanted to sign. I think he'd said, if we marry, you sign agreement, was what they quoted. That's not me being anti-Greek. Anyway, Mr. Kennedy's lawyers were insistent that she sign it the next day, the 21st of September. Her lawyer gave some speedy advice not to sign. She said it was entirely inappropriate. It only protected Mr. Kennedy's interests and in no way considered her client's interests. It's just so that we know sort of how that, what the agreement actually said. It gave her a monthly allowance during the marriage of $4,000 a week, which it may seem a lot, but that's very little in the scheme of things.
In the scheme of 18 to $24 million.
Exactly.
Was it $4,000 a week or a month?
A month.
A month, yeah.
Yeah, while they were living together, so that she was allowed to live rent-free in a penthouse he planned to build during the relationship, so not after, and her family was going to live in another unit. But if they separated within 3 years, she got nothing. If they separated after and that's with or without kids, if they separated after the 3-year mark with no children, she would get $50,000. So she's relocated to Australia, set up life. She loves this man. Yeah. She wants to have children, was the evidence. $50,000. If he died while they were still together, which was the only risk she thought she faced, she would get the penthouse apartment, $1.5 million and $5,000 a month. So that's if he died while they were together. She signed the agreement 4 days before the wedding, and she actually signed another one 4 months later. After 4 years, they separated, and Ms. Thorne went to the family court, and the judge threw out the prenup and the post-nup on the grounds of undue influence. And the judge pointed to the financial inequity, the different positions, the lack of her permanent status in Australia, her reliance on him, the fact she was in love with him and was desperate to have a child with him, the public nature of the upcoming marriage, and the time pressure on her. So that's another important part. He appealed, and in the full court of family court, which is, I guess it's like our high court, they said, no, that prenup's fine. That was not duress. She knew what she was signing. She knew what she was signing, exactly. It wasn't enough. That kind of pressure is not enough. So luckily, someone supported Ms. Thorne to go to the High Court, and in the High Court, a panel of 6 judges said that the trial court was right, trial court judge, that she had no options available to her that were fair and reasonable, that it was open to that first judge to conclude in the light of the combination of factors that Thorne had no choice or was powerless other than to enter into the agreement. And the kind of crux of that undue influence was that they said that the wife was subject to a special disadvantage when she entered into the agreements, which I guess was all of those factors, but particularly she'd have to leave the country if she didn't marry. He was aware of the disadvantage, and he took advantage of it to get her to enter into the agreement that was entirely inappropriate and fully inadequate. So it was that combination of factors.
Because the courts have always, there is always going to be an element of
pressure,
influence and pressure because of the very nature of them. It's just where that becomes seriously unjust.
And I think the point there, she knew what she was entering into. I don't think that dilutes the fact that it was still a seriously unjust agreement.
Well, and like they say, it wasn't just that it was seriously unjust, it was also that there was an influence that she had not. Yeah, she was.
I think that was more the pressure on that. In that case, it was the pressure
which
of it.
He was taking advantage of in pushing it. The case does talk about things like amendments. They weren't prepared to make substantial amendments to it. Now that's something that is a big part of our work, isn't it?
Yeah.
It's how you make it fairer for people. Do you think had that agreement been more balanced, there would have been the same outcome?
if she got 10,000 or 20,000.
Yeah.
I think it has to be relative to the pool, like what the otherwise asset or relationship property pool would be. So
$50,000 after
50,000 as a percentage
after 3
of
years.
But I mean, I guess we don't know the ins and outs in terms of a lot of that wealth was possibly going to be separate property anyway. But yeah, I think if it had been more forward thinking, like if we're together 2 or 3 years, this is the outcome. If we have kids together, I've done an agreement where a young couple were entering into it, and I was acting for the female. But what I suggested to her, and which ultimately happened, is that in the event they got married or had a child together, the agreement became null and void essentially. So that was a good way of protecting it in its infancy. The pull from a relationship that might have terminated early, but actually was more appropriate if they continued on with the relationship.
Yeah, and there's a few different future-proofing things like that you can do, can't you? You can stage it so that once they have kids, maybe they share KiwiSaver and incomes. And increases in the home, or it can be.
The other thing to watch out for, I think, for people is review clauses. So people think, oh, that's all right because we've got a review clause in there. But the way that most review clauses that I see drafted are that actually it's only if both parties agree to make changes it'll be changed. Otherwise, the agreement continues on in its current form, which is essentially useless because
it almost makes it worse, right? Because you can say, "Oh, we pulled it out, we discussed it. It must have still
I
been
wanted
fair."
to make changes, but she didn't. So we're just tracking along, and it's just pointless, really.
Because have you ever actually changed an agreement with a review clause?
And do they ever even remember to review it, like in the 5-year mark?
I've had a few reviews, but usually it's when they're changing, they're buying a house.
I've had definitely addendums.
Addendums,
different scenarios. And that is a balanced process because I do think you have to be careful of setting up milestones in a way that affects
that trigger
them actually hitting the milestone.
Yeah.
So you say you get another $1 million or whatever when you have kids, and
or
so
together 10 years.
Pumps the brakes.
I'm not going to have kids.
That's
so
absolutely right.
it is really nuanced and it is so person specific.
Yeah, absolutely. Like all these agreements, they're bespoke.
Yeah.
They're not cookie cutter.
And they take time to get right. I think time to discuss at home, time to talk to your lawyer.
The other kind of tip the other style I guess I've adopted is in my background I have a really detailed narrative, a snapshot of their relationship and their financial status and their jobs and their income earning.
I love that.
At the beginning. You see a lot of agreements which basically say they started to living together on date and that's it. And they just want a contract out of the act. Well, if I'm not picking it up in 10 years, but another lawyer is, that's kind of useless.
Yeah, if it's being challenged, it's hard to,
and they're both agreeing that these are the facts right here and now, and they're both signing it. So there's kind of less room for wriggling out of that.
It also makes the other lawyer's job easier because there's a whole lot of facts that they can just say, is that right? Is that right? Is that right?
Yeah.
Okay, have you ever found yourself not wanting to sign off an agreement or actually not signing off an agreement because it was so unfair and you could see that they were being pressured?
Absolutely, and I genuinely felt that the person was not, I couldn't sign their certificate to say, like, they did not understand my advice because of pressure in one case, or another one because of the language barrier. Like it just,
they wouldn't have been making that decision.
They wouldn't have been making that the educated decision about the terms of the agreement.
So what about if it's really, really, really unfair, but they totally understand the effects and implications?
Yeah, so
can you sign off on that?
I think you can, because I explain to clients, it's not my job to tell you what's the right or wrong thing to do based on morally what I think is going to be good for you long term. My job is to explain the law, explain what the agreement is providing for you, and for me, feeling confident that you're understanding my advice.
And the implications of what you're signing longer term.
Longer term, then I will sign off on it. But I will generally get the client, I will summarise that advice in a letter, and I'll get the client to acknowledge that despite my advice not to sign, they wish to proceed regardless, and they know that there's a risk involved with this moving forward, that the agreement could be overturned. So, I mean, there have been occasions where I've simply said, I refuse to sign off because I don't think you understand. And I say to them, look, you might find a lawyer who will sign this off, but unless or until this agreement's changed in some way, I just don't think you're understanding
And
the
sometimes
ramifications.
that can tip the balance too. Like there's often a bit of a power imbalance in
Always,
discussing.
generally, yeah.
So it's quite powerful to have a partner come back and say, my lawyer
Just won't
says
sign
she's
it.
not going to sign it because it is so unfair. Yeah.
What are we
Maybe that
gonna
will
do?
change
Stay
something.
on it.
Yeah, what
Yeah.
are we going to, exactly. And then he can go or she can go back to her lawyer and say, okay, how could we make this?
Yeah.
What are the things?
What are the minimum?
Is that true that it might get thrown out?
Yeah.
Yeah.
I think collaboration with your colleague on the other side is really
Yeah.
important too. So again, thinking that we've got a continuing relationship, we want these guys to, be together.
Yeah.
Trying to get on board with each other and understanding the different positions and collaborating
I
as
love
much
it.
as
I love
possible.
it when a lawyer picks up the phone and
Yeah.
because you can cut through so many different things and you
Rather
can
than
say
email
something.
wars or
Yeah, you can
Yeah.
say something in jest that cuts to the heart of it. That sounds like a
Yeah.
bullet in a letter.
yeah.
I reckon we jump to the quick fire questions.
Okay. Yes.
We've covered some of our other ones.
Okay.
So this is quick fire question time. You have 10.
Should I be nervous?
10
Yes, definitely.
Yeah, so you get 10 questions. Actually, there's 12 questions today. 12 questions with 12 seconds each to answer them. And
And you can pass.
no,
You're
you can't
first, I
pass.
think.
I'm first. Oh, can you DIY a contracting out agreement?
To an extent, but not without legal advice.
Okay, good. Does a contracting out agreement take hours, days, weeks, or months to get done?
All of the above.
Oh,
Oh,
okay.
that's a good one. Is there a generational factor to prenups or contracting out agreements? Do you see as many baby boomers as millennials wanting them?
There possibly is a bit more of a trend with the younger generation. It's more normal to operate your finances separately. Yeah.
Yeah, and maybe people aren't getting together so early as well.
Yeah.
You're in your 20s.
Well, I think too the concept that you might have multiple relationships in your
Yeah,
life is
yeah.
more a millennial
Yeah,
thing than
yeah.
a boomer thing, which is you were married generally once, and that was
Like an albatross.
it's like your jobs. You used
Yeah.
to stick at one job forever.
Okay, this is particularly pertinent. Sorry, I know that's 10 seconds, but having...
It's for the answer. We're allowed to take as long as we want for the question.
I do have the name of my ex-husband,
Beloved-
but can
beloved
you
ex.
make someone give up your name after a divorce?
No, I don't think you can.
Yeah.
That's good to know.
Unless you've got a specific order from the court. But
Yeah.
no, I think you can your name can be what you like it
Yeah.
to be. Yeah.
Awesome. What is your top tip to beat imposter syndrome?
Oh.
Not that you would ever have
Yeah, I mean,
experienced
none of
it.
us have
No,
experienced
not at
it.
all, never. Fake it till you make it.
Okay.
Yeah.
When making work wardrobe decisions, do you find yourself more influenced by Suits or Legally Blonde?
Probably legally wrong.
I think that is one.
That's it, yeah.
Okay, if you were in a Taylor Swift song, would you be the one wearing high heels or the one wearing sneakers?
High heels.
I was going for the other one. What beverage would you associate with your husband asking you to sign a prenup? A cup of cold sick. B, a poisoned chalice. C, a tall glass of water. D, whiskey sour on thin ice.
Whiskey sour on thin ice.
Yeah.
Yeah.
Or all of the above.
All of the
What would you say has been the classiest celebrity divorce? Apart from mine, obviously.
The classiest. I think the classiest are the ones we don't know about, to be honest.
Nice, good call, good call.
It's funny, on the way down though, we were talking about Sports Cafe, and we were talking about in the media there was like the Matthew and Sally Ridge back in the 2000s.
Yeah.
There was quite a lot of coverage of
Yeah.
that. I remember, I think I might have been like a law student at the time, but no, I think the classy ones are the
think I was
ones
saying
that are
babies.
anonymous and you don't hear
Yeah,
about,
yeah, it's
as
good.
they should be.
Yeah. Okay, your best on-screen lawyer.
Oh, on-screen lawyer, Erin Barakovich.
Oh,
Yeah. What is your favourite dance move?
The worm.
We were going to bring it up if you
So
didn't.
we've heard. I thought it was the caterpillar actually.
Oh, the caterpillar. Yeah.
If you weren't a lawyer, what would you be?
A dentist.
What?
The frying pan.
Or I'd own a lawn mowing business.
Lovely.
A lawn
Excellent.
mower.
Okay.
Okay, our last section, it's called Best Question Ever. And for you, Amanda, that question is, what is the one professional experience that you have had that changed your perspective on life or work forever? that you can talk about.
Yeah, no, it's all above board. Actually, I think, you know, there's that funny saying about like when one door closes and you feel like it's the worst possible outcome at the time, but it means that another door is opened and otherwise would not have opened.
Don't tell us you applied for Web Ross.
No. But I think it's when I had a knockdown from another firm very early on in my career, and it really gave me the drive to kind of be like, you know what? I am a good lawyer. I can do this. And that's what led me to do my master's actually during my working career, because I thought I can do this. Like, I'm interested and I'm good at this. So yeah, it's just so funny things like how life pans out, right? You know, like I never would have ended up at Edison Reeves, which I love, and I probably never would be doing relationship property law, which I love, and so.
Sometimes it's good to remember the criticism then, eh?
It's like I feel thankful for it now. But at the time, as I say, I was like broken. But so I think you've just got to remember that. Like, you get knocked down.
Cracks are where the light shines.
All of that.
And I think that applies to a relationship property as well. And there's nothing like someone telling you can't do it to make you want to do it.
So, thanks, Amanda.
Thanks for having me.
This has been Divorce Cafe. We hope you found something interesting about this episode. If you are interested in listening to other episodes, you can find them on our website at hendersonreeves.co.nz or look up divorcecafe.co.nz. We have an article in the show notes and other information, links to other information about contracting out agreements, and join us for another episode another day. See ya.